alternative dispute resolution is and how much it can offer to our community as far as ways to engage meaningfully and come up with meaningful resolutions when we find ourselves in disputes in our lives. So we're very pleased to join you today to talk about alternative dispute resolution in our community. So often disputes in families, with caregivers, neighbors, business partners, and others can disrupt our lives and intrude upon other things that we would prefer to do with our time and money and energy. Alternative dispute resolution, or as some say, appropriate dispute resolution, or ADR, is a way of disrupting the cycle of conflict and its negative consequences in order to create workable arrangements to allow parties or families or communities to move forward. As we deal with some of the challenges of being an older American or in the family of an older American, conflicts can erupt, whether over caregiving or finances or communication, estate issues, concerns with neighbors, work accommodation issues, or something else. And alternative dispute resolution can assist by helping to organize the dispute and encourage productive conversations that can often help to resolve the disputes. And often those resolutions are built by bringing everyone to the table and having meaningful conversations. It is sometimes seen as an alternative to court, but courts are not necessarily involved at all. They don't need to be involved at all. Anyone finding themselves in a dispute here in Western New York can definitely find their way to ADR. I'm really happy to have been invited to work with this amazing panel, and I wanted to just take a moment to first introduce you to our Erie County Surrogate, Honorable Asa M. Mosey. Judge Mosey is a lifelong Western New Yorker. She spent many years in private practice and as the Erie County Public Administrator for 14 years before being elected as surrogate judge for the County of Erie in November of 2017. Judge Mosey is incredibly involved, not just with her court and the courts generally, but also in our community. She sat on the board of our zoo. She sat on the board of Children's Hospital and is otherwise involved in the community in so many ways. We could be here all day just talking about that. She's so active in our legal community, being involved in so many of our local bar associations as well. And also in the past had worked extensively with the family business, also investing here in Western New York. Her leadership in the courts is well known and well respected, not just here, but across our state. And after her election to surrogate, she was actually asked by Judge Marks, who's up in the command of our local New York State courts. He is the chief administrative judge of the entire state of New York. And he asked Judge Mosey to serve as chair of the administrative board for the Office of Public Administrator. She also serves on the advisory committee to the chief administrative judge of the courts of New York and is the chairperson of the subcommittee on joint and convenience accounts. Needless to say, her days are busy, and we're very fortunate to have her join us to talk about ADR, which she's really been a leader on in Western New York, and I'm anxious to hear what she has to share with us today. We're also joined by Krista Gottlieb. Krista is a private attorney in practice here in Western New York, but she considers herself to be a resolutionary, someone more involved in resolution than in litigation. Krista was very involved in bringing a lot of the alternative dispute resolution to Western New York that we have today, including being on the boards that put together the Western District of New York Federal Court program many years ago, and deeply involved in creating the local state program as a stakeholder in our courts. She's also been an attorney and counselor at law for over 42 years and a neutral, acting as a mediator, arbitrator, and neutrals in other ways for over 27 years. She's really been a trailblazer in ADR in our community, also a very busy lady, and we're also very fortunate to have her to join us today. We're also joined today by Sarah Jo Whalen. Sarah Jo Whalen is senior law clerk to Judge Mosey, so she works here in the surrogate court, which was nice enough to loan us their space today. And Sarah is an up-and-coming leader in the Western New York community. She's a member of many of our local bar associations and an active part of her court that she works in with Judge Mosey. Ms. Whalen started her legal career working as a paralegal and then a law clerk for several local firms, but I'm most interested in the fact that you have a history background and a master's, which we're going to discuss afterwards. But right now we'll turn back to this and talk a little bit about alternative dispute resolution in our Western New York community. We're going to start first with a PowerPoint that we'll share with you so that we can follow along all together. see. And just this morning, we heard from about our panelists. I'm the moderator, Bridget O'Connell. I work as the Regional ADR Coordinator for the Western New York area under the Deputy Chief Administrative Judge's Office. And we've met our panelists. We're going to turn now to talk a little bit about how conflict happens. What is ADR? We'll talk a little bit more deeply about mediation with Krista. We'll talk a little bit about how ADR can help in these matters, and we'll talk about how to find and navigate your way to ADR. And then, of course, we'll be answering your questions in the chat, as Christy mentioned as we started today. So first, I think I'm going to turn it over to Sarah to talk a little bit about ADR and conflict. So let's go with that.
So in general, there seems to be this perception that conflict is always a bad thing, and that's not necessarily true. Conflict can show us something that we thought was black and white, and really there is a ton of gray area in between, and that opens up the possibility for there to be compromise. So there's generally this, I don't want to say it's a saying, but this idea that mediation or compromise means that nobody leaves from the table happy. Everyone's a little upset, and that doesn't have to always be the outcome or the result when you're dealing with mediation and ADR. There can be a lot of development from compromise and conflict resolution. It allows people to essentially walk in the shoes of the person that's sitting across the table from them. So you're able to hear a lot more about maybe why someone holds that position or that idea. And you can actually get to the base of the conflict instead of just having these potential insults or issues that come up with regards to conflict. So there's a lot of benefits to ADR that you don't get from a lawsuit, and that would be preservation of the relationship. So especially when we're dealing with older individuals and families with older individuals, there can be a lot of discussions about where are mom and dad going to live. Are they going to be staying in their home? Are they going to be moving into a care facility? And you can have siblings or other family members that have very strong opinions on what is best in those types of situations. You may also have disputes over who's going to serve as mom and dad's healthcare proxy or their power of attorney. And instead of having these issues potentially blow up and ruin a family dynamic, this is where ADR and conflict resolution can be very productive, because you can actually have a meeting of the minds. Everyone can have their opinions and beliefs heard, and there may be a very easy compromise that can be resolved out of those discussions.
Jump in real quick. When we send people to ADR or ask people if they'd be willing to participate in ADR, oftentimes, since we started this program just a few years ago, instead of having a lawsuit started, or instead of people writing things about each other, they have an opportunity, as Ms. Whalen said, to sit across the table and discuss things with each other, maybe see how the other person is feeling. And oftentimes they have come back to the court, and I am very grateful to hear that they have preserved their family relationship and they have been able to resolve this on their own. If I hear the case and it goes to a hearing, then it's all or nothing oftentimes. One person, quote, wins, one person loses, and it's me making that decision. ADR gives you the ability to have your voice heard and to cooperate with each other and to decide what is best for you together, whether it's with a family of 5, whether it's with a family of 10, whether it's extended family and even more people. You could make your own decisions and you could determine what you want to do. In front of us, in front of the court, again, oftentimes that's an all or nothing situation, as Ms. Whalen was saying.
There's also a lot of benefits when it comes to the savings on court costs and time. We all know we just lived through a pandemic for the last 2+ years, and that has caused significant delays across the state in all courts because of the lack of staffing and other issues. And so going through an official court proceeding at this point in time can not only take months, but years before you actually get a final resolution, where if you have everyone is willing to come to the table and have a discussion, you can have a decision within days or weeks. And that would be a huge time savings and also cost savings when it comes to attorney's fees and other things.
And our court is going into right now, if you're to schedule a hearing here at the Surrogates Court, we're into October or November. Mm-hmm. That could be 2 months, 3 months that you're working together towards resolution. And maybe you resolve some and not all, but at least you're coming here with more done. And we're doing it in a concurrent path, which Ms. O'Connell has helped me learn how to do this, because when I first started, we didn't have ADR in the court. And based on the pilot program that she put together on behalf of the Surrogates Court, we're able to let you work together for a few months, even though we might have scheduled the hearing. So the hearing may be scheduled for, let's say, November 15th. But from today, if we send you a referral out to ADR until that day, you could be working towards resolving the entire case or even parts of that case. Mm-hmm. And as Ms. Whalen said, the cost savings for you and for the estates that we have here, or any of the guardianships or whatever might be before us, the cost savings is tremendous. And then you have to recognize you're then receiving what you were looking to get from the estate or the guardianship much sooner. So you have the use of that money much faster. If you were to wait for that November 15 date that I gave as an example, that's not the decision. That's just when the hearing is. Then you might be waiting for a decision. That decision might be appealed by the other opposing party. And you might be talking about having a judicial settlement, accounting, and the distribution of your funds, maybe if you're lucky, sometime next year. So that is a huge time savings and cost savings.
I think we're ready for the next slide. Thank you. So what is ADR? Alternative Dispute Resolution is what that acronym stands for. And it also goes by a variety of different names. You might hear it referred to as conflict resolution. There's really two main branches of what we're talking about, though. There's mediation and arbitration. So both of these systems rely on the same fundamental principle, and that's going to be a neutral third-party negotiator. Now, the difference between mediation and arbitration is that negotiator in mediation is not going to necessarily be binding. Arbitration is essentially, for lack of a better term, a side court or a different path, where the neutral third-party arbitrator is going to function a lot like a judge, and their decision is going to be binding on all of the parties. So the arbitrator is the one who actually makes the final determination in those situations. Where mediation, you're going to think of that third-party neutral as more of a guide or a therapist in some cases. They're going to be trying to make you see the other side's points and perspectives. They're going to be presenting issues in a devil's advocate way, perhaps. They're going to really try and get you to think outside the box, get out of the position that you're in and think about more creative alternative solutions. And then you may settle in that settlement if it's put on in front of the court or turned into a settlement agreement would be binding, but the mediator is not the person deciding what the settlement will be. That is something that the parties have agreed to that then just gets written down officially by the mediator and presented. And so mediation is really what our court deals with and what we're going to be focusing on our discussion today.
Thank you so much. I think, Judge, you mentioned some of the costs that come with this, and Ms. Whalen, you mentioned that as well. And I think that when we talk about costs, we're thinking about financial costs, the cost of time, but also the emotional costs that
Yes.
come with having a lawsuit or having a dispute sort of hanging over your head, informing your days, wondering what's going to happen, and the cost of those unknowns are they're really vast. So I want to turn it over to talk a little bit about mediation.
And you already have it on paper. You can't take it
Right.
away.
Right.
So you've said these things, you have to read them about yourself, maybe write them about the other person, and that never goes away. Once you memorialize those things, once you're saying them in a testimony form, you can't turn back, and they're already out there. And to mend that later is so much harder than to not do it at all. Or to be saying it to each other across the table instead of writing it about somebody.
Right. The chance to clear it up right then while you're all in the same room,
Right.
as opposed to letting something linger out there in papers and affidavits and.
And then you're talking to your attorney about how to respond to that.
Right.
Or you're deciding how to respond to it if you're pro se and don't have an attorney, but you're living it. And without the ability to immediately resolve it.
Right.
So
I think that that's so important. And I want to talk a little bit about how mediation really works and sort of get into the meat of that. Krista Gottlieb is, as I said, an attorney in town and a resolutionary and mediator. She was also really instrumental as a bar stakeholder in working with the Surrogate Court and our other courts to help us think about how the work that the courts do impact our community members and the members of our legal community and their clients. And I think, Krista, if you can talk a little bit about sort of what mediation really looks like and tell us a little bit about some of the benefits and how it doesn't necessarily have to be something we just access through the courts.
And that last part may be the most important part. It is something that you can access in order to avoid court and all of the things that Judge Mosey described, which tend to polarize. So I would describe mediation as a guided, considered conversation versus a fight or an argument. Or if you're fighting and arguing, you're doing it in the presence of a neutral person who assists you to find a way to communicate more effectively and to do so before you end up having to go to court and ask someone else to make a decision for you. Mediation is about self-determination. It is you. The you being a plural you, the you in that case includes all of the parties that are affected by whatever the issue is, whether it is mom needing more care, whether it is the brother and the sister that are in town versus the brother and the sister that are not in town and how they're going to help mom do that. It's about where mom needs to go into a nursing home, which nursing home should it be, how do we manage her finances. All of those conversations happen long before people go to court. It's when those conversations go bad that people say, well, my brother, my sister, my aunt, whoever is involved is being unreasonable. I can't get any answers from them. We can't talk to each other, so I'm going to court. By then, you're already very, very polarized. And then, as Judge Mosey said, it becomes difficult to have people have a more meaningful problem-solving conversation as opposed to an argument that is trying to persuade a judge to make a decision their way. These are conversations that are being held with the intent to understand each other and to come up with a joint resolution for whatever the issue is for each other or for the person that you all care about. And it comes up in very, very many contexts, including something as simple as who will be a power of attorney, or who will be a healthcare proxy, who will be making caregiving decisions, what are bioethics and things that happen at end of life if mom is or dad are really failing, what are their desires, who should be making those decisions for them, who should be having the conversation with them. All of those things create a great deal of conflict. Never mind, should we be spending mom's money on mom, or are we preserving mom's money in order to save it for us to inherit? Or disagreements about those in the family who think it's mom's money and mom should use it, and those who think that mom really wanted to preserve it and doesn't really need it. So those are all very, very difficult conversations. And Having arguments about them that a judge will then decide what happens to your parents does not necessarily help either you or your parents or each other if you are in conflict, or if your parents have passed, then the arguing about what your parents had intended. You can have those conversations, as I tell people, early and often. So you have them before there is conflict, you have them during conflict. What makes mediation different is that they're not conversation between just the people in conflict. They are guided through that conversation by a trained professional mediator who has the skill set to assist in helping make those conversations more meaningful through some of the methodology that Ms. Whalen mentioned, perhaps reality checking, perhaps devil's advocacy, looking at it from a different perspective, asking people to step in each other's shoes to see it from the other point of view. And what I often tell people is listen with the intent to understand, where are these folks coming from? Why are they holding the beliefs that they hold? Rather than the intent to respond, as in, you're wrong, I'm right, I'm going to defeat you, and I'm going to convince someone. This is a conversation about what's really best for mom. I don't agree with you, but I want to know why you think your way is better for mom, because I know we both care about mom. And having those conversations can be very meaningful. So how does the process work? You agree to mediate. You agree to go through that process. That means you're going to hire a mediator and select a mediator. You're going to work out how that process is going to work, usually with the guidance of the mediator that's going to tell you this is how we do it. However, you are in control of both input into how that process is going to be, because you're the one who knows each other and the conflict and the issues most effectively. And then have the conversation with the mediator so that they can design what is basically a customized plan in how do we go through this? Who should be at the table? Who should not be at the table? Who needs to have a voice that maybe not have one now and that can be heard, that could then disrupt whatever we talk about? We don't want to have a conversation, we all agree, but then there's someone else who has the ability, we all agree what we should do with mom, but it turns out mom gave a power of attorney to somebody who's not in the room. And then we have to have a discussion again because that person was not included.
And Ms. Gottlieb, if you do that before, it's going to work the way that you're saying it. If you wait until it's coming into the court, we decide who you're using and we decide who's at the table. That's a big difference. And like you were saying, before and during the conflict, if you start on the ADR path right away, you'll already be there by the time you get to the court. And it's going to be your decision who you're using and who's at the table and who's being heard, versus waiting to have it come here and our referrals, which is still wonderful. And we have a wonderful panel of people, but it's decided by our court who you're using. Obviously, we eliminate any conflicts that there might be. And then we're also deciding the people that are necessary at the table. And that's a big difference. And I really didn't think about it till just now when you said that. Before is so important and often.
And the important part is that if you do it early, you will never have to see the court, because the whole point of it.
Though we love seeing everyone here and you're always welcome, but I do agree. It is nice
when
not to.
necessary, it is fantastic to have a court as receptive, as caring, and as open-minded to other ways of resolving conflict than simply have the court make the decision. The objective, however, is not to have the papers drawn, because once you have that polarization, it is very, very difficult to undo. Not impossible. So if you are already in conflict, then this is a very good methodology to try and deflate it and put it on a different path. However, if you sense there will be conflict, or if conflict begins, that is the best time to have those conversations and understand that the presence of a neutral person in the room changes the communication dynamic by that one thing alone. It is someone else present in the room, not just you and all the folks that you would be talking with. Because if you're families, you're going to have family dynamics. those shift instantaneously once a neutral person enters the room. Even before I say anything, my very presence makes people do things differently in a constructive way, not in a intimidating way, but simply people behave differently when there's a neutral person there to assist them. And that is a beneficial thing because it breaks the dynamic that may be part of the issue and allows people to have more constructive discussions. And through all of that, you get all of the benefits of mediation, which allow you to avoid conflict, reach resolutions without having difficulties with other folks. It is way faster because you can, depending on the mediator schedule, but other than that, it is something that is very quick. I mean, it is lightning speed compared to working your way through the system, although our surrogates court here is absolutely phenomenal in the way that the judge is able to move her calendar along. That's not entirely true of other courts. In other courts, you're looking at years to get hearings. So there is the cost of being in conflict for that period of time and not knowing what the outcome will be versus in a few weeks or months being able to work out whatever might have been an issue for years or would be an issue for years if you decided to go into the open conflict and the polarization, because our system of justice is called the adversarial system. And it's built on the principle that we present things from an adverse point of view so that the judge can decide. Mediation allows us to look at it collaboratively, and we listen, as I said earlier, with the intent to understand rather than respond in defeat. So it's a different way of having the conversation. And you get to mediation by deciding and then looking at the various resources. The most important thing about mediation is the preservation of relationships. It does save time, it does save money, it does save emotional investment. Most importantly, though, it can deal with emotions, which are part of all conflicts, not just family conflicts, and that underlies some of the positions that people take. You have sorrow, fear, anger, frustration, joy, jealousy. There are many, many things that come into play, and mediation is a much more respectful way, and it's a place where we have time to do that. Courts do not deal with those things, but those things are driving the conflict. So if we can deal with them in a constructive way, not as therapy, but in a constructive way in terms of finding a way through them and understanding that they exist and what they may be and sharing that with each other, that allows us to move together. Plus, we can share information which might not otherwise be available that will be beneficial for our objectives. It focuses on commonality rather than at the adverse components. It focuses on we're really here because we care about mom and dad. We're here because we want to help them. We're here because we want to talk to each other and not sue each other. And so it builds on collaboration and self-determination. You will be in control as opposed to the win and lose that Judge Mosey described earlier, which would come out of conflict.
And one of my favorite slides, first, can we agree that this is a big backyard? Like, you're finding the common ground. And Ms. Whalen, thank you. She always makes these slides so wonderful. But there are going to be some parts that you agree. And that's a really good starting place versus immediately it's the conflicts that are brought to the court. Maybe before you're getting here, there can be agreements as to what is common ground, as Ms. Gottlieb was saying. And those are important because it gives a base then of we agree on all of these things, and that's a great foundation. And maybe there's only a few things left that needs to be decided by the court. But the big foundational portion, we all agree on. So even if you're getting partial agreements and partial disagreements, you're still much further and better off, again, with time, with cost, if you at least make that attempt first.
And the fact is that you get to have a better conversation, even if it isn't arguing about what's best for mom. Maybe it's talking to mom. Maybe mom has her own ideas about what it is. And maybe mom has capacity, maybe mom doesn't. But having the conversation, including her, and have somebody say, okay, so let's break this down. How do these things work? Tell me where you're coming from and why you think mom needs this. And mom, why do you feel that your independence is being intruded upon by what your children that really care about you are talking to you about? And then be respectful of everyone's opinion and then try to come up with a way without shouting and yelling, although sometimes you can raise voices, depends on families. There's all kinds of family dynamics that come into play, but not doing it in an argumentative way, in a way that is intended to come up with a resolution. And as Judge Mosey said, sometimes that means you can only go so far and then you reach a wall where you can't get through it. Then you can seek decision-making for that piece. Most of the time, though, if you build the kind of foundation that we're talking about here, you then have the ability to say, you know what, it's better for us to work this out together because nothing hurts mom and dad more than a fight between the kids about mom and dad. That is something that I hear all the time in the elder mediation things that I do is I just want them to get along. And the argument between the kids really is they all want the best for mom in their view. And this is a way to try and give them an opportunity to not hurt mom in the process of deciding that and to really hear each other instead of just saying I'm right and you're wrong. So it's an option. And you have numerous options locally that you can explore.
Right. Before we move on to that, I just wanted to ask, I just highlight a little bit about what you said. One of the things is that when we're allowing ourselves to really listen with the goal of understanding where the other party is coming from, what their interests are. I think one of the things that we're seeing is that we're allowed to expand the conversation beyond what a court might be able to hear, beyond what we even might think about bringing to the table ourselves when we have someone there acting as a neutral, asking good questions, following up on things, repeating what you said so that everyone kind of makes sure we heard the right thing, there aren't misunderstandings, and then sort of moving on from there. So we're allowing ourselves to have that bigger conversation. There might be one small matter in dispute or several matters in dispute, but the conversation can involve matters far beyond that. And I think one of the limitations in a court space is that the court needs to hear really mostly about what exactly is before the court and what the court is being asked to decide. And so the mediation option does give that opportunity for a more expansive conversation as well.
I think that's critical.
And think about just the setting. You have somebody on a witness stand being asked questions, and then you're done with them, and then you go on to the next person. There's no interaction. Mm-hmm. So the forum itself is not conducive to the interaction that you were just talking about. You know, you are in a very structured setting for a hearing.
Yeah, and it's similar to when you see in movies on the witness stand is just answer the question. don't just answer the question. And the beauty about mediation is it's not about just answering the question, because there is more to be gained by listening to what the person chose to tell you when the question was asked than the actual answer to the question. But in the court, you are limited to what the court has jurisdiction over. And there's limited things that the court can do. Whereas in the broader conversation, as Bridget very aptly described, allows us to deal with all of the things, even creative problem-solving issues that the court could never award. So we often have conversations in mediations about, let's talk about the things that you can gain through this process that you can't gain even if you go to court and win. Because there are some things like that the courts just don't have the power or the ability to give and grant, whereas you can gain them by agreement with the folks that are involved that might have the ability to give them to you. So that broad conversation is about whatever is necessary for the resolution of the conflict rather than what is necessary for the legal arguments that are being made.
Good point.
You're not boxed into, I call it the black box of the law. You're not limited to the issues that are in that black box. You can talk about anything that's important to anyone that will help avoid the black box of the law.
And we've talked a lot about sort of family caregiving arrangements and how this can be used in those kind of settings. Are there some other things that come to mind that are sort of part of elder law or thinking about elder law where we might
Maybe estate planning.
Yes.
A lot of the planning of what is going to happen later, not only what's happening now, but what is happening later, but powers of attorney and the healthcare proxies and the wills and the things that they're planning for later, who's receiving what, those things being done in advance.
Particularly if there are things that need to be taken care of, perhaps sometimes family businesses,
Yeah.
homes, real estate, anything that is of a value. How is that going to be dealt with and how will it be perceived? Very often you can even have conversations with parents and children if parents have certain thoughts about how to manage their estate planning. And it is helpful for parents to communicate that to children so that the children know it was the parents' wishes rather than this was my sister or my brother influencing mom and dad to do whatever mom and dad ultimately do, because that can lead to conflict. So any of that forward planning, the best thing to do is to have conversations as families when parents or siblings or whoever with special need folks are in need. Having those conversations early and often is very helpful to see what is happening, what is changing, what will these folks need, what are their desires, whose money or assets are we talking about, what kind of assets are we talking about, how should it be managed, is there a family business, are some of the kids in the business and some of the kids are not in the business, how do we deal with that in order to be fair so that the kids not in the business that are not in the business afterwards challenge those who are, if there was an intent by mom and dad to benefit them in some fashion. So there's all kinds of things, any kind of interfamily dynamic, including the political discussions at the Thanksgiving table, might be guided into less dangerous territory by a neutral mediator. But it really is any of those elder law issues that come up that help the conversation and give voice to some people, because it's sometimes in family dynamics, some folks don't feel comfortable speaking up about themselves or someone else in the family. And mediation really gives them a much better voice and ability to say, hey, this is what I think and this is what I feel in a respectful way with taking everyone into consideration.
Sure. And just because we're an older American doesn't mean we don't have everyday problems like neighbors and parking arrangements and shared driveways and all those things. So I think that those are places where mediation can also be really helpful, internal business disputes, all of those things. Let's talk a little bit about how we find mediation, because I'm all in. I was all in when I walked in the door, but just hearing you talk, all of you, has been so inspiring. And I think that it really tells me a lot about how mediation can be used. And I know that folks that are listening with us today want to hear about how they can find a mediator.
So there are a number of places, and you can see up on the screen that certainly brainstorming and trailblazing judges like Judge Mosey have programs that have been developed in order to allow the courts, once you have escalated to that point. So the courts can be of assistance. You have Community Dispute Resolution Center, which we'll talk about a little bit in more detail. And then you have private mediators. Most of the private mediators are folks who are also on the court rosters. Some of us do it full time, like I do. Some do it in addition to practicing law in other capacities. But what private mediators offer is truly the most amount of time that you're willing and able to pay for in order to allow the conflict to be dealt with as is appropriate. So you can, when you are in conflict, the two thresholds for me would be community dispute resolution centers and private mediators as a potential prevention of having to go to the courts. Yes. If you've escalated to the courts, then they are available again. And in fact, when you go to court, you will go to those processes, because there is now presumptive mediation in New York State as well as in this court. So I tell people all the time now, if you're going to go to court, you're going to end up in some form of ADR, more than likely in mediation. So take the bull by the horns, take control of your own destiny before someone else makes you do it anyway, and do it before you have polarized and escalated. Seek out those folks who do this, who have skill and experience to do this. And you find private mediators online. You can, there are court rosters that all the folks that also are on the rosters have private practices. And you have the community dispute resolution center. So when you're thinking of, I need to hire a lawyer, think about who would be a good mediator to prevent the necessity for me and everyone else in this conflict to have to hire a lawyer and the costs associated with that. Not that the lawyers don't earn their keep, because they do. They do an excellent job representing everyone, which is what they're supposed to do. They are advocates for particular positions and people. Mediation, however, allows the positions to be gone beyond, to go to the interests of the parties in order to try and resolve what's really driving the positions. So think about mediation when you think about litigation before you get there, or if you're there, or if you want the advice of an attorney through mediation, you can be in mediation with attorneys. So you can have mediations with just the family members or whoever is party to the conflict. But if it has escalated to the point where someone or everyone has obtained the advice of an attorney, bring them on along, because that can be very helpful. They are not the mediators, they are your advocates, or whoever hires them advocates. But the mediator can then work with them, and then you have the benefit of the advice of that attorney who is your advocate to discuss the issues that come up with and the guidance through the mediation process.
Right, it's definitely not an either or situation.
That's
you can
exactly
always
right.
have guidance, and it's often recommended that you have guidance
That's right.
by, a qualified attorney in whatever area you might be dealing with.
Exactly. It's good to have a device in addition to information, because mediation can share information, but it does not give advice. So if you want somebody to say, hey, I've been told yada, and what do you think I should do under these circumstances? That's when you seek advice of an attorney, and the attorneys will then tell you what all of your options are, including going to court and then being sent to mediation through the court system.
So our courts have websites, courts.gov is sort of the overall for our New York State courts, and the Western District of New York also has their own website, and the panels of mediators are found on those websites. Our community dispute resolution centers we'll talk about a little bit in a minute. And then there's also very active mediation groups in town through our bar associations. Independently, we're very fortunate that our local law school has really active work going on in the ADR field. And so there's lots of ways to sort of navigate your way through there. And of course, we'll let the Department of Senior Services and some of our other hosts today know a little bit more about how you can reach us if you need to. Well, let's move on a little bit to talk about those CDR. Well, actually, let's talk first about, Judge, I'm just going to turn back to you and Ms. Whalen for just one moment, because I think we touched on this, but I want to make sure we're pointing it out. Mediation happening outside of court is a fully confidential process. It is not something where what happens in mediation is shared with the court.
Correct.
Even when mediation happens under the court's direction, what happens in the mediation is wholly separate from what the court knows.
Unless it forms into a settlement agreement.
Of course.
And then the settlement agreement can come back to the court, be made part of the record, and then abided by. In case later somebody doesn't follow that, then they can come in front of me to have it enforced.
Right.
But any other information that isn't in a structured form does not come back. No conversations come back to us. No written materials come back to us that went to the mediator. We do ask people to send to the mediator anything they want to go through with them in advance, and any of the issues. That does not come to us either. So unless it is shared through a formal document or later in a hearing, somebody might say the same thing they said in mediation, but unless it's part of something formal here back at the court, it is not shared. So there's no predisposition. You're starting on a clean slate when you come back to the court if you need us for anything.
And why is that important? Krista, do you want to say a little bit about why that's important?
It's really critical because when you're thinking about problem solving, you can share information with a mediator and in the process that will actually help you get to a resolution. But it is information you would not want the court to know because it might influence how the court would rule on some of the issues. So your flexibility and your collaborative approach is different than the adversarial approach. So you might not want to let someone know that you are as flexible as you are if you are in a win and lose, because there is no compromise. So the confidentiality of the process is truly critical. So what I compare litigation to sort of Las Vegas, but similarly to Las Vegas, mediation, what happens in mediation stays in mediation. It does not come out of there, meaning whatever you say cannot be used against you. You can't say, well, in mediation, you were willing to do such and such. That is protected, and the court is not going to be aware of it. So if you have conversations and you've already gone down the path a little bit, but you can't make the last piece, then you go back to square one, clean slate, as the judge put it, for the judge to be not influenced by your flexibility. That would
Right.
not be, so you're protected and can have those meaningful conversations and share with the mediator things that you don't necessarily share with the other side, but the mediator then has the knowledge to help work with the other side.
I mean, you can't come in a formal setting, for example, and say, you know, what really matters to me and the only thing that really matters to me is the car I used to work on with Dad. That's not part of what a hearing is. The hearing is saying you're going to get a third, whether that includes the car or not. And that's something you can do in mediation that you couldn't necessarily do in a hearing setting, that you're saying, I want my third. You can actually pick what that is and the parts and pieces that you specifically want.
As opposed to sell the car instead of letting me have the car and the value of the car, because the car really matters to me.
Right. And all I could say is you're getting a third. And, you know, if you figure out later
Get the
that
first third of the car.
the first third of the car,
It
you
makes
get
the headlights.
you get a wheel and a half.
And that's the point. That is kind of a description of what can happen in litigation, that the things that are really the object of litigation get destroyed in the process.
Yes.
That you can't really deliver the things that really matter, because if I really want the car as opposed to the value of the car or 1/3 of the estate, then that's not necessarily the best place to get it. That is something that you reach by resolution. And sometimes people don't identify what they really want until they have those broader, better, listen with the intent to understand discussions, that it's really, you know what, I really don't care about any of that. I just want the car.
And can we go all the way back to the first time we started this 45 minutes ago? Do it in advance. Talk often. Let everyone know you wanted the car and Mom and Dad wanted me to have it. So Mom and Dad, please tell
Put it in
the
the
other,
will.
put it in the will, or tell the other two siblings how important that is. You know, that's so important. And I keep resonating what you said. Speak often and start early and make sure that the communication is there. You don't want to hear, well, I'm not going to be here. I don't care what happens later. You guys deal with it. That's when there's the conflict. That's when there are the issues.
Right.
That's, if Mom and Dad say that, you should have the kids say, okay, we're going to deal with it now.
Agreed.
Sort that out right now. We're really fortunate here in Western New York to have a very active, very engaged Center for Resolution and Justice at Child and Family Services. They are our local community dispute resolution center. I know all of you are familiar with their good work. Every county in the state has a Center for Dispute Resolution available to them. As I said, here in Western New York, that is Child and Family Services Center for Resolution and Justice. Their contact information is here. You know, obviously this slide reiterates a lot of what you've heard already. Don't wait. You know, family dynamics are so challenging, and the local community dispute resolution centers can help because they can offer low or no cost mediation in some circumstances for those that can't afford to hire a private attorney. They also work with the Surrogates Court and the Help Center that Judge Mosey was so instrumental in setting up and having function all throughout the pandemic, all these days. Yeah, really amazing work goes on here under her mentorship. So do think about knowing more about your local CDRC, our local CDRC. I was fortunate to talk to their director, Julie Lesh, just recently, and she wasn't able to join us today, but she shared some stories that about what has happened that they have found most revelatory around these sort of elder law issues. One is that they have found themselves often called to assisted living or nursing homes in order to be accessible to those that might find online mediation challenging, or wouldn't be comfortable coming into their offices or are unable to travel easily to their offices to be part of a mediation session. So I thought that was really an important thing to know. She also told me a story about a grandmother who had a grandson who had some past challenges, and there was some difficulty and some trust issues in that family. And she felt that she had talked to the Center for Elder Law and Justice, and she was concerned that these complicated sort of longstanding family dynamics were resulting in her grandson taking advantage of her in some way. And after the folks at our local civil legal services providers worked through this, they weren't able to find that there was an actual legal issue that could be managed, but they did make a referral to mediation. And after that mediation, what it turned out was that the assumptions that were being made about this grandson who had had some challenges in the past, where there were some trust issues, he actually was the one who was working to keep his grandmother in her home, which was her goal. He was sort of quietly doing some work, contributing some funds, doing some things that were going on that she wasn't aware of. And as those kind of came out at the table, as different goals were explored at the table and different ways of working this through for the family came out, it was really something that was a game changer for this family. They were able to negotiate and come up with a formal communication plan, so there weren't going to be these kind of confusions going forward, and talk about how to continue to keep her in the home safely and who could contribute and be part of that to sort of help with that. So I think that tells a little bit about how families can benefit from sitting down together. This kind of communication plan, this opportunity to understand. Sometimes there are assumptions because of, when you're in a family, you've been together for a long time often. So there's a lot of assumptions, a lot of mischaracterizations of what's going on, perhaps misattribution of what's going on. And so that was a really lovely story that she shared. And I thought that idea of also being able to go, to the parties who need them is so important.
Bridget, I just want to say one thing in here.
Yeah.
That one of the important things about access and accessibility of mediation is that particularly in today's environment, when health issues are coming and going constantly, it can all be done virtually. So you have, and that's one of the things that needs to be clear. You can do it in person, but you don't have to. I've never done a virtual mediation until the pandemic started. I've done 2 in-person mediations since the pandemic started. And they are just as successful when you do them on video. They feel different, but they work just as effectively. And sometimes they can work in a better way because people are more comfortable being in their environment, and they allow you to do it with folks who are either far away and can't come, or are in some sort of other constrained circumstance so that they can get a computer, but they can't leave their environment. So it's really totally flexible and customizable.
I think that real loss in that is the snacks you normally have. You
Yes.
have snacks and
My
treats
snacks
for all of
are
us.
very
when we
much
mediate.
missed. Yes, I haven't figured out how to deliver them virtually yet, but they're much more dietetic that way.
No, that's true. That's true. So this is just another slide reminding us about our local Center for Resolution and Justice. They also offer, in addition to mediation, conflict coaching, which is kind of a one-on-one opportunity to work through how to engage in a difficult conversation, whether that's preparation for mediation that might happen, or whether that's an individual conversation that, because someone won't agree to come to mediation, perhaps one of the parties who would have wanted to participate in mediation goes through a conflict coaching arrangement with this CDRC and learns a little bit about how to better manage a private conversation that happens without a mediator, without a facilitator, in their home or in another place, and sort of feels more prepared for that conversation. It's a really remarkable effort that they have put that together, and it really is very successful. And I could use it in most of my daily interactions.
We all could.
We all could. So I just want to finish. We didn't get any questions that I saw coming in, but I just wanted to let each of us have sort of a final word to wrap up, and we'll end with you, Judge Mosey. So I just want to thank everyone for joining us today. We are pretty close on time. Krista, is there anything you want to say a little bit about maybe sort of painting us a picture of the way you hope ADR will look in our future in the courts and in our culture?
I'm hoping that ADR is going to help us shift from an adversarial culture of polarization to one of collaboration and discussion. I think we really need that as a nation. We need it as individuals. We need it as families and communities. There are so many conversations that are so much broader than just the issues we've been talking about that would really benefit from meaningful listening and conversations. So I think of mediation as being the facilitative process for people to have meaningful communication about issues regarding which they disagree. You pick the topic. If you disagree on it with someone you care about, mediation might be a good way to find a way to bridge the gap of those conversations, which we really need to do. We don't necessarily have to agree with each other. We simply have to have meaningful, open conversations, which allow us to gain a much better understanding of our fellow carbon life forms, as somebody recently described us, that allow us to have better understanding, because that allows us to deal with all of the global issues as well as the personal issues better. And having a neutral person help us do that, or a group of folks in a group setting conversation, that can be very helpful. So when you think you're in conflict and you need to go run to a corner, hire somebody to represent you to defeat the other person, take a step back and say, hey, is there a way we can have a conversation with somebody who can help guide us through this process, whether it's your neighbor, whether it's somebody at school, whether it's your the nursing home caregivers and your mother, whoever it may be, can you have a conversation that would be assisted by somebody that would make it better and make the outcome better, faster, cheaper, smoother?
Agreed.
Sarah, what are some of the things you notice when people come back from mediation?
I agreed with everything Ms. Gottlieb just reiterated. One thing that I would say is that it's never too late to start the process. The courts it's a much more rigid system than I think a lot of people believe. And so there's, to talk about a recent case, there was a family dispute where we had an initial hearing and there was evidence that was presented that, based on the rules and the statute that governed that kind of hearing, we can't take any of the evidence that person presented into consideration, because that's not the basis of that type of proceeding. And people don't realize that. So even if you may have text messages or family photos or whatever, or diary, things like that, those are not necessarily things that the court can take into consideration based on the laws and the statutes that are in place. And so after we had that initial hearing, that conclusion was presented to the parties that, hey, your evidence here really had nothing to do with what the basis of this hearing was. We were able to guide them into ADR, and hopefully there will be a resolution in that case. But so even if you have come to the courts already and there is some animosity there, ADR is still possible. And we have that happen quite often here, where they are in front of us. We have ordered the ADR and given them the referral to go there, and they are able to settle oftentimes. So even if there already has been conflict, or you feel that these parties are already too far gone, that's not always the case.
Thank you very much. Judge, why don't you wrap up for us? I know you took mediation training yourself because you're just a lifelong learner. You've seen so much, you do so much, and you've been such a great leader in our community about ADR and bringing it into the court and just fostering a conversation in our community about it. How would you like us to wrap up?
Well, as you know, I was not a firm believer of ADR.
I was going to say that.
And Ms. O'Connell came to me and convinced me to start a pilot program. We did. We've embraced it. It's been 3 years now. It was instrumental during COVID, when people couldn't come in and they were able to resolve things virtually, as Ms. Gottlieb had said. My favorite story, which happened last year around this time, there were 5 family members, 3 lawyers. It was getting very ugly. And as Ms. Whalen has pointed out, it's never too late. I ordered them, and I've only ordered it twice. Normally it's participant and they want to go and they all agree to go. We ordered to ADR. The family came back around early December. Not only did they have a settlement, they had Thanksgiving dinner together. And the cousins saw each other for the first time in 4 years since the parent died. And it's just heartwarming to see that. And not all stories end like that, but even one, it's worth doing.
Perfect. Perfect way to wrap up. Thank you so much for all of your time. Judge Mosey, you run one of the busiest surrogates courts in our state. We're so grateful that you were able to share
Thank you.
your time with us. And Sarah, you're working in one of the biggest surrogates courts in the state. We're very fortunate to have had your time as well. Krista, you're such an incredible advocate and ambassador for ADR and all that you do and all of your work. And we're so grateful that you were able to join us today as well. So Krista Gottlieb, Judge Asa Mosey, Sarah Jo Whalen, and I want to thank all of you for joining us. And we look forward to seeing you next year. Thank you.
Thank you.
Thank you, maybe in person.
Thank you. Thank you very much, everyone. I appreciate you taking your time and providing such thorough and informative discussion for everyone joining today from home. If you're joining us tomorrow, we'll be presenting on Medicaid planning and eligibility. Again, thank you everyone for joining. I appreciate your time.
Thank you, Christy.
Bye.
Bye.